Well, good afternoon, everyone. We'd like to welcome you to episode 4. Happy 2020 to all of you. Fair Housing Vision for 2020. So we have an exciting program for you today. Just to take a minute and introduce both Kathy and myself, just so you can this is your first time here. Kathy Williams is a partner in the law firm of Williams and Edelstein, PC, providing defense and preventative representation for the housing industry in all civil rights matters. Kathy is also a co-founder and president of the Fair Housing Institute, an online LMS and webinar training company. So we're very grateful to have you, and we look forward to your comments on some really important topics. My name is Jonathan Sarr, and I am the Director of Marketing and Public Relations for the Fair Housing Institute. And I also have an extensive background in professional development and compliance-related topics. So, Kathy, welcome to the show, and welcome everybody.
You know, Jonathan, I just have to correct you a little bit.
Okay.
My law firm is now called Williams Edelstein Tucker, PC. So we've added a partner, and I just want to make sure everybody knew about that.
That's right. That was exciting news. Very good. Yes, congratulations. That's fantastic to see that kind of growth. Okay. So thank you everyone for being here. Just a few housekeeping items. This is going to be a little bit of a different format for what you traditionally would call a webinar. We're going to have you get a lot more interactive with today's program. So if you have your smartphones, now you don't have to be necessarily at the same computer where you're watching this program. If you want to take out your smartphones and go to slido.com. You can see it there on the top on the screen, and type in that event code. It's hashtag FHI 2020. So again, slido.com, hashtag FHI 2020. So today, there's going to be a few fun features that are going to be available to all of you. A lot more polls, which we're going to do an icebreaker in just a minute to get you used to this little app that we've decided to use. And not only that, after we do a poll, we want to know what topics are important to you. So we're focused on 3 today. In a minute, you're going to be able to choose and see what's the most important, what's on your mind for 2020. After that, you're going to have an opportunity, instead of having all the questions at the end of the session, we want your questions now. Share them with us. And you're going to have that opportunity to vote on all of those questions. A little like or a little thumbs up. And so if you see a question that's been on your mind already, go ahead and give it that little thumbs up. And that way it'll kind of curate all the questions of what's on your mind. So as you can kind of gather, this presentation it's for you. We want your feedback. Kathy's worked very, very hard to make sure she understands a lot of the new items that are here for 2020. Okay, so why don't we start off? Anybody have any questions? You can try and put it in the chat, and I'll do my best to answer them as we go along. So again, go to slido.com and type in that event code, and we'll give you a couple minutes to try it out. So just some other housekeeping items that you notice here on the screen. We'll read them out loud just for emphasis sake. There will be a recording for this session at a future date. Last year, we were able to put them out on YouTube and provide a transcript. So something similar will take place for today's program. This session does not constitute as legal advice. For legal advice, please consult your attorney. There are no certificates of completion for this education session. So if you're doing anything internally, then that's wonderful. Okay, so just give me a second, ladies and gentlemen, and let me get the first poll up. It's our little icebreaker poll.
Yeah, I see a lot of comments, Jonathan, that they're concerned because Slido says the voting is closed and it's not open. So
Okay.
I think that's what you're going to do right now, correct?
Yeah, so it should be on everybody's screen. What is your favorite romantic movie? Okay, we're already getting some votes in, so we know it's working for people. We thought in honor of Valentine's Day that we might put this little question out, get everybody in the groove of doing live voting. All right, so we've got 140 plus votes coming in. Keep it going. So far, Kathy, looks like Notebook is reigning strong.
Wow, that's right.
I think my wife would agree with that too. She's one of her favorite movies.
Wow,
Okay.
over Titanic and Sleepless. Interesting. Notebook is much more recent, that's for sure.
Yeah, that's fairly newer. So I noticed a couple comments. Again, I'm sorry I can't accommodate everybody. We've got a lot that are voting and are okay. So just as a reminder, it's slido.com and then hashtag FHI 2020, and that will get you into this event. Okay. But if you're not able to, enjoy the show anyway. Okay. Thanks very much, guys. So we're gonna close the poll out right now. So thank you everybody for participating. So it looks like Notebook was the number one that came up. I'm going to switch it to your questions. So tell me if you see that on your screen. There we go. So if you want to put your questions in now, and I'm going to help circulate them to the top. Okay, we're getting a lot of votes on this first one, service animals and companion animals. Okay, very good. All right, so we're going to close the questions. So the first one that we have, Kathy, and we'll be able to dig into the presentation now. And keep asking your questions, and I'm going to be able to feed them to Kathy as they come in. So thank you, everyone. Apologize for that one poll, but we really do appreciate your questions. Okay, so the first question that came in was, what is the difference between service animals and companion animals? That was the first question that came in on our poll here, Kathy. So I'll leave it, take it away for us.
Okay, well, when I talk to you today, I'm really going to focus on HUD's brand new notice on assistance animals. And that just dropped about a week and a half ago. For those of you who have not seen it or heard about it, it is a notice that is in two parts. The notice is dated January 28th, 2020, so you can probably Google it. And it has an attachment to it which came out before the notice. The attachment came out on the 24th of January. And it's called a fact sheet on HUD's assistance animals notice. So I'm going to try to focus on that because that is the newest source we have on how HUD views assistance animals. And oddly, or interestingly enough, HUD does make some changes in this notice. In fact, it specifically says HUD's former notice, which was dated 2013, is no longer active. This notice takes its place. So we won't be referring to its prior notice anymore. And in this notice, it uses a lot of references to the Americans with Disabilities Act and that definition of service animal. This is kind of an odd reliance, I think, because as you know, as housing providers, the law that's important to you is not the ADA, it is the Fair Housing Act. And of course, those of you who do federally funded housing also have to be concerned about the requirements of Section 504. So when we look at the Fair Housing Act and Section 504, we don't care whether an animal is a service animal or an emotional support animal. We don't care. It doesn't matter. We don't need to ask different questions. We certainly can't ask for proof of training or some kind of certification. All of that, when it comes to housing, is irrelevant, even though it's important under the ADA, but it doesn't apply to housing. So HUD, I think, causes some confusion in its new notice by beginning the entire notice with questions pertaining to service animals. In my opinion, if you've seen a notice, you can disregard all of those questions about service animals. And so the legal or technical definition of a service animal is an animal that has been trained to work, perform tasks, provide assistance for a person with a disability. The ADA limits those types of animals to dogs. And as you know, as housing providers, you cannot limit the type of animal to a dog. So again, I think the ADA references are somewhat confusing in the new HUD notice. Mm-hmm. Oddly enough, again, maybe it's interestingly, I need to quit saying oddly. Interestingly enough, this new notice comes up with a completely different type of animal that the notice refers to as a support animal. And then in the definition, it talks about other animals that do work, perform tasks, provide assistance, or provide therapeutic emotional support for individuals with disabilities. I believe that what HUD has done by coming up with yet another term called support animals, has expanded the definition of what we thought was the second type of assistance animal. The first type being service animals, and then the second type has been pretty much defined as emotional support animals, animals that are not trained, they're just there to provide a therapeutic benefit to their owner. What support animals does is it expands beyond emotional support into, I believe, other types of animals other than dogs that provide services to their owner, useful for their disabilities. I don't find that definition helpful in how you process requests for reasonable accommodations to permit assistance animals, but I'm just kind of throwing that out there. I don't think you need to change anything you've been doing based on HUD's emphasis on either service animals or this new term that it uses in this new notice called support animals.
Okay. Interesting. Okay. We appreciate that. Lots to take in. Here's one question, Kathy, that is really coming up a lot from not only the app, but in the chat screen. Multiple animals. Does the notice talk about that? What's your comment on requests for multiple assistance animals?
You know, that was one of the disappointments of this notice. It begins in the very beginning of the notice of explaining that multiple animal requests will be handled using the same analysis or procedures as that's being used for one animal. And then it never mentions it again. So I don't find the notice helpful at all in handling multiple animal requests. And that does seem, from my perspective and talking to my clients every day, that is a huge problem that is only increasing. So I would go back to what we're going to be talking about as a way of processing the request for reasonable accommodation. And I would ask questions about each of the animal, the need for each of the animal, and make sure that both the resident and the verifier has explained why one animal isn't enough. There is a presumption that one animal is enough. That doesn't mean that someone couldn't justify more than one, but I think the burden is on the resident or the applicant and their verifier to explain why they need more than one.
Okay. That's excellent. So here's another big question. And this one's from Taryn Lewis. A really great in-depth question. I think it's going to cover a lot of other questions that some of our attendees have mentioned. So her question, we're getting a lot of applicants who say that they do not need to provide verification regarding their pet since it's a service animal. How do we differentiate whether it is a service animal or ESA based on the new guidance? If I worded that right, Taryn. Thank you for the question.
So again, that kind of takes us back to this concept of the ADA. Under the ADA, operators of public accommodations are permitted to ask if someone brings in an animal into, let's say, a Target store and is walking around the aisles with their dog in their arms or in the basket or wherever, and the manager of the store or an employee can walk up to that person and say, is that a trained service animal? And if the person says yes, they are permitted to say, and what work or task has this animal been trained to perform for you? And they're supposed to answer that. However, there's no written verification, there's no confirmation, there's no verification of any of that information. If the animal's not a dog, then it's clear it's not a service animal, because only dogs, and in rare cases, miniature horses, are recognized as service animals. So in housing, if someone says, I don't have to provide you verification of my service animal, the answer is that is the Americans with Disabilities Act, and that does not pertain to housing. The Fair Housing Act does, and it permits verification when the disability and the need for the animal is not, and again, going back to the notice, they call it observable. If you can see it, if you can see this as a guide dog, then you certainly shouldn't be asking for verification. But if it's a dog that, for instance, is a service animal, but alerts someone to, possible hearing problems, or alert someone that they're about to have a seizure, you can't see that when you talk to the person, the resident. So you can ask for verification. And if they talk to you about that's not permitted, then you have to clarify, I'm asking you this not under the Americans with Disabilities Act, but under the Fair Housing Act.
Got it. So how does that apply then with different disabilities? So you mentioned there a minute ago, some things are very obvious, and there's been quite a few questions that have I think you're really hitting the nail on the head, Kathy, when it comes to what you say, how you say it, the questions. You mentioned one a minute ago about sometimes it's very, very obvious that it's a service animal. Is there anything in HUD's notice that talks about dealing with things that maybe aren't noticeable? Like, has anything changed with that?
No, there really isn't any change to that. The new notice talks about observable and non-observable.
Mm-hmm.
When a disability and a need for an animal is observable, then the housing provider should not verify that person or their animal. If it is non-observable, then you have every right to ask for verification of whatever the information is the applicant or resident has provided to you.
Right. Okay, good. So another one that's come in quite a few times in different wording, but here's the gist of a few of the questions that have come in. And this has to do with what's considered proper certification. We're seeing that a lot with websites that provide certification. So we have this question from one of our attendees: what is proper certification for service animals? Would certifying your pet online be acceptable, or should the certifications come from a doctor? Now, is that new in the notice, or is that still something that we're still having to wrap our heads around from last year?
Okay, I'd like to make a difference between what I call verification,
Mm-hmm.
what the new notice calls documentation. And that has not changed. However, HUD has made it very clear in this notice that going online and getting your pet registered or certified on a website, paying money, is irrelevant to the question of whether this is an assistance animal that should be approved to live in housing and the reasonable accommodation that goes along with that. So my suggestion to you is if someone hands you one of those registrations or certifications, that you hand it right back to the resident and let them know that is not adequate to verify their need for an assistance animal. We don't care whether the animal, again, what I told you before, we don't care whether it's a service animal. We don't care whether it's an emotional support animal. We only want to know if you're disabled, if you meet the definition of disability, and if that animal is necessary to assist you because of your disability. That's all you care about when you're verifying a request for a reasonable accommodation. The HUD has made it very clear. It considers those websites as taking advantage of people, wasting their money, because those registrations are irrelevant to the question of whether you approve their reasonable accommodation or not.
Interesting.
Jonathan, I just looked down and saw a question pop up. How do I get a copy of the new notice? Go online and Google HUD's assistance animal notice, and make sure that the one that pops up is dated January 28th, 2020.
Yeah, thank you, Gail, for that question. Appreciate that. So just so I can wrap my head around it, and for our audience today, don't get so wrapped up in what is presented to you as a property manager or as a leasing agent, whatever your role is, from a prospective resident, but focus on what they need to prove, their burden of proof based on ADA regulations. So does this, now again, you may have touched on this, but we got a lot of questions coming out. Does this fall back on the documentation, their property management company's best practices, policies, and procedures, that it is so critical not only to review those, but to make sure that all on their team are following them step by step, no matter what case that they're being presented with. Is that a fair assessment? Any thoughts on that, Kathy?
Absolutely. When your property is looking at a request for an assistance animal, I hope you have a pretty detailed procedure that you follow, that all staff at your property follow when considering a request for an accommodation. So that's what you follow, and that involves verification, again, when the need for the animal, when the disability status of the resident is not observable. And by the way, another thing the notice says is that if you're going to turn down someone because you don't think their verification is reliable or for whatever reason, you need to conduct a interactive meeting, which is a good faith dialogue with that applicant or resident, explaining why you are not going to accept or grant their request. Now, that should also be done in writing, but the law is pretty clear now that you shouldn't turn down a request for a reasonable accommodation, including one for an assistance animal, without someone talking to the resident and explaining the situation. Sometimes this new notice may be helpful for you to support why you are turning the request down. And if so, you could refer your resident to the notice to explain why you are not accepting. For instance, let me give you a really good example. One thing the notice does help with, there are a couple of things the notice helps with. There's a lot it doesn't, but there's a couple of things it does. One thing the notice says over and over is the verifier has to have information about the resident and should be providing the resident with either medical or mental health services. Mm-hmm. So if someone goes online and purchases a letter that says they're disabled and they need this animal, there are questions that you can ask to determine if they just went online and purchased that letter, or if they have an ongoing medical or therapeutic relationship with that person. And you don't have to give nearly as much credence to a verification where it is clear that the person has not been meeting with that, for instance, a therapist, and all they did was have one evaluation, and then they sent them the letter. I just got that situation that came in yesterday on that kind of fact pattern, and this notice gives language that you can cite to say why that verification is not going to be deemed reliable, and therefore you're not going to accept it.
Okay, excellent. Thank you, Kathy. So, and I want to just take a minute to thank Kathy, Sean, and Mary. You posted, it looks like, some references to what Kathy was highlighting that dives into this notice. So appreciate you being part of the fair housing education group here, helping each other. So, and it is big. Someone, when I read it the other day, is 19 pages or something like that. Kathy, I think you told me. I was looking at it.
Yeah, it's pretty long altogether with the attachment.
A lot there. And so it really, it goes for everyone who's on this session today. It's really, really important. It is the hot topic that's out there. You don't feel comfortable, talk to leadership. I think Kathy really emphasized how important that is. Just, you have to have documentation. You have to have a procedure that you follow, and you have to be consistent with that. And if you're not sure, or you don't feel comfortable because you get so many different questions, like for instance, this one, Kathy, this one it's got to be at least a half dozen, if not more. And you might have touched on it already, but because it's come in so many times, I just want to share this with you. Alana are asking about this website, petscreening.com. Any Were you aware of that? Do they kind of fit into the same pattern of burden of proof? I'll turn it to you.
Oh, what was the name of that website again?
Petscreening.com. It's shown
Okay.
up a
Yeah.
few times on the chat and on the questions here.
Yeah. I have run into those, and some of my clients use those, use that service. You pay for it, obviously. I think it's useful. It would pull out any past problems that made it to the courts that a pet caused. I think that service also provides very basic, processing for requests for assistance animals. I doubt, and I guess because I tend to see the problematic requests for assistance animals in my law office, I doubt that that's going to be very, helpful in maybe getting to the specific issues you may have. For instance, this registration, this website registration issue. So it's a private company. It's out there to provide services. I don't have anything good or negative to say about it. It is not the registration certification websites I'm talking about, which are there to send a card to one of your residents that say, your dog Fido has been registered as an emotional support animal. And then the resident brings it to you as verification. It's that documentation that you can accept it if you want to, but HUD has made it very clear that you don't have to. They don't think it's relevant. And I wouldn't even take it that would be my advice, because I kind of feel bad that the resident got snookered into buying it.
Yeah. Okay, good. Thank you, Kathy. And again, there's more that are posting some nice information. Jessica and some others sharing some documents from HUD. So Kathy, we probably still have a couple more points to consider under this new notice, but it might be helpful for our audience, the takeaways. There's been some changes, little amendments, some things to think about. Some things haven't changed. For everybody on the call today, what's the takeaway? What does leadership need to do? What does people on site, what would be your summary of the action items that should take place after today's session?
Okay, well, you know what? I think the notice gives a couple of good statements, sentences that you can use, literally quote, right in your request or verification forms. And then I want to see somebody criticize it, since it came right out of HUD's notice. There's several of those, especially the one about the fact that verifiers need to be providing ongoing medical or mental health services to the resident. Things like that. So there are ways you can use it. The notice also makes it clear that if the animal is other than a dog, cat, small bird, rabbit, hamster, gerbil, other rodents, fish, turtles, other small domesticated animals that are traditionally kept in the home. If the animal is other than that, such as goats, think of this, pigs, chickens, and of course, snakes, which is the one that bothers me almost the most. If it's any of those, the notice says the resident has a substantial burden to be able to show that they need that odd, unusual, not normal household animal as an assistance animal. Now, it doesn't make it impossible, but they're going to have to jump through several hoops to be able to prove they need their snake as an emotional support animal. We didn't have that in the past. We had nothing like that. So I am definitely going to revise my forms to include that kind of information. The other thing that the notice says is if you require the resident or verifier to notarize their information, you need to stop that. And if you have the signer of your forms sign it under penalty of perjury, you need to stop that. So I've not seen anyone that has done that, but just be aware that the notice makes that pretty clear. I don't think that changes the fact that you have statements or things you can use to try to let the resident and the verifier know this is serious. You want them to be truthful and accurate. There are things, many things you can say. They just said those two forms of, whatever we call that, a threat, if you will, should not be used on your forms.
Very good. Okay. Well, that was a major deep dive, and we thank you everyone for your questions.
You know what, Jonathan, since we kind of need to move on, this is such a huge topic. We literally could talk about assistance animals for hours and hours.
Yes, we could.
We are going to provide on our FHI website a thorough review of the new notice. So it'll be a week or two before it gets up. So you are welcome to go on our website and check that out. I don't know what section that will be under, Jonathan. That'll be up for you to decide.
Yeah, that'll probably be in our news or our blog section. So all of you who are subscribed to our mailing list, you'll receive a notification, once that comes out, because it is there's a lot there. So thank you, Kathy. And there'll be some opportunities for some other questions to be answered at the conclusion. We're going to try and head over to Twitter. We'll give that a shot. We haven't done that before. But anyway, thank you for the questions, and thank you for everyone who's been helping. Like, there's been a lot of people, Kathy, there's been some questions coming in. People are sharing websites and documents and sharing feedback and really helping a lot of people out. And so we appreciate everyone's audience participation in helping in that way.
That's great, because we're trying to kind of turn these webinars into more of a discussion and a community where there are so many of you out there that can provide such good assistance to the webinar participants. So I'm delighted to use our webinars to bring the community together and support what you all are out there doing. And a lot of times it's very difficult with lots of questions. So what a great use of the webinar. Thanks for everybody that's doing that.
Yes, absolutely. Okay, so we got about 15 minutes left to cover the other two topics, Kathy. VAWA, lots of questions came in. A lot of them are just basically, so what's the deal? What's happening?
Okay.
What's going on?
All right. Well, this is a much briefer topic. Primarily, I wanted everyone to realize that the Violence Against Women Act did not get reauthorized by Congress. It had to be reauthorized by November of 2019. They didn't make it, and I see no hope that it will make it in 2020. Therefore, I wanted to just mention the issue is, so what does that mean? So let me just back up for a minute. The Violence Against Women Act regulations that HUD did in 2016, which are very detailed, very burdensome on the housing providers. Those regulations apply to any properties that do federally funded work or housing and rural development properties. And they have all kinds of forms to use and procedures to follow, and it's pretty complicated. So that applies to those housing providers. Then the 2013 VAWA and the requirements of the statute also applies to low-income tax credit housing, which are a huge swath of the housing industry. You don't have specific requirements to follow if that's your property, unless your state housing finance agency told you to follow the HUD regs. So you kind of need to know that, because the HUD regs don't automatically apply to you unless your housing finance agency said they did. And so the issue that the lack of authorization causes are the HUD regs, do they continue to be effective? Will they continue to be enforced? And what I can tell you is I don't know.
Yeah.
I contacted all my sources. I have heard nothing. That HUD is taking the position that absolutely should continue to follow the HUD regs, or no, you don't have to. I would think it's probably less risky to go ahead, for those of you who know you're covered by those regulations, go ahead and continue to follow them for now. For you in the low-income tax credit industry, you need to find out what your state housing finance agency is saying about this, and whether they want you to follow the HUD regs or not. If they don't, then the issue is, you follow just the basic statutory requirements, that you don't refuse to house someone that has a bad landlord history, and that bad landlord history was related to the violence. And you don't try to evict someone who is the victim of domestic violence, dating violence, stalking, or sexual assault. So then in a more general way, let me just also mention this. I have had in my office a number of cases where HUD has viewed a situation involving a female that was evicted for something that could be assumed to involve domestic violence in the household. And they have taken that case on as a complaint of sex discrimination because of the disparate impact that domestic violence has against women. So my advice to everybody, whether you're covered by VAWA, whether the statute is active or not, I would advise everybody to be very careful when you are involved with a tenant situation or an applicant situation that possibly involves domestic violence. I would go back and make sure you check your facts, the situation very carefully, that you're just not ignoring that as a possible reason for whatever is causing either the denial of an application or the termination of an application.
Okay. There's a few questions that came in. I just want to make sure you covered. There's one that seems to pop up a few times. Low income housing. Is there anything specific that that VAWA applies to that? You have any comments on that, Kathy?
Well, it depends on, if you're talking about low income housing that's HUD-subsidized, then those HUD regulations would apply.
Got it.
So I assume if you call it low income housing, you're probably required, at least you were covered under the VAWA statute and the HUD regs.
Got it. Okay. I think that was there's only a couple questions that came in while it's still open. Anybody else have any other questions regarding the VAWA regulation before we move on to our closing comment, or a closing topic?
One more point I want to throw out. If any of you find yourself challenged in the next year by a VAWA situation, make sure that your attorneys understand that you could argue you're not covered by VAWA, nor is anybody else, because it's no longer an authorized act of Congress. I don't know that would be successful, but make sure everybody understands they ought to try that at least.
Right, right. Very good. So another question just came in regarding this is from Doris. Thank you, Doris. How do we protect ourselves from residents who continue to allow the offender into their home?
Yeah, you know what, that's the hardest issue with the entire idea of domestic violence and trying to provide rights to victims of domestic violence. What is very clear is you cannot make the actions you take based on the violence. However, if you have informed a resident that you have banned a former resident or this person who has perhaps abused them in the past, you have banned them from the property, and if they allow them on, that they are then in violation of their lease. So if they allow them back, it's not because of the violence, it's because they have violated their lease, which is a separate issue. So that is something that you can work with your residents to understand.
Got it. Got it. Here's one, and I don't recognize the acronym, so forgive me, whoever posed this question. On VAWA, they used to be very vigilant with MORs, and
Yes.
VAWA. Will they
Management,
still be that way?
Yeah, we'll see. We'll see what happens with MORs in the future on this issue. You were required to have policies in place. You were required to have an emergency transfer policy, and those, I'm sure, were being checked in the MOR process. Whether that's going to continue or not, I don't know. Got it.
Okay, thank you, Kathy. All right, so our final topic is financial accommodations. So we're just interested in knowing your comments. And what is that? Why in 2020? Why are we paying attention? We'll filter some more questions if you. Well, actually, hang on. Before we skip to that? One other person came in and asked the same question I did. Just explanation. What are MORs? And then we can go to financial accommodation.
Yeah, an MOR is, let's see, I think it stands for Management Operation Review.
Okay.
And it's the review that's done on federally funded housing by the contract administrators in place of HUD. Management Occupancy Review. Thank you. I missed the O. It's Management and Occupancy Review. Thank you, Mary.
There we go.
Jason, thanks.
Cheers to our attendees. Very good.
Yay.
Thank you. Yay. That's awesome. Okay. Thank you for that. And if there's any other questions, we'll get to them as we kind of close out today's session. So let's jump back to financial accommodations. I know this was another one that was important, shorter than where we were with the assistance animals, but what's your take on it for 2020, Kathy?
Well, the reason I wanted to talk about this topic is because I keep seeing lawsuits that are being found against the housing provider when a matter comes up that most people in most companies would view as a request for a financial accommodation. And in the past, let's say 10 years ago, we would have always said, well, that's a financial accommodation, not a reasonable accommodation because of a disability. And therefore, no, you don't have to grant it. Now that I'm seeing so many cases, I'm starting to want to ring the bell that you better move slowly, carefully on these, and just don't reject them without a careful consideration. So let me give you some examples of when those situations might arise. The one that I've seen the most about is a resident who receives only, because of a disability, SSI or SSDI, meaning that their sole income source is because of their disability. And those checks used to go out on the first of the month. Something happened in Social Security, so now they come out all during the month. But let's say they come out on the 15th of the month, and the resident asks you to alter their rent due date from the 1st to the 15th, because that's when they get their SSI check. There were a lot of cases on this in the past that said, no, that's a financial accommodation. I have seen 3 or 4 in the last year that said, yes, that's a reasonable accommodation and the housing provider should grant it because their disability is the reason this is their source of income. I think it's particularly important if it's their only source of income. If there's other sources of income, I don't think you don't have to grant it. If it's their only source, you should take a serious look at it. Now, if you can show that that is going to completely disrupt your program, then you could refuse based on the fact that it would be a fundamental alteration. But in the cases I've seen, they actually dug into that during the trial. And what it came out to be was it was going to be a minor computer alteration. And the court said, no, that's not a fundamental alteration. That's a few clicks on your computer programming or whatever. So be aware of that. So that's one example. Let me give you another one. There was a recent case filed by a man with serious disabilities against Habitat for Humanity. This man had applied to receive one of Habitat's homes, and Habitat does some income verification to make sure that once the person moves into the home, then they could continue to support it. And when they did that, they found out that this man only received income from SSI and from food stamps, and he got a little over $100 a month from his father. Well, Habitat said, no, sorry, that is not consistent with our source of income criteria. We don't use food stamps, and we certainly don't use contributions from your family. You have to show that you can make this, it was approximately $10,000 from other sources, not those. And the court, the district court found in favor of Habitat. The appeals court turned it around and sent it back for trial on why couldn't they make a reasonable accommodation and permit him to consider those other income sources. For those of you who determine net and gross income on your residence, that could be huge. So we want to watch that. Again, it's kind of a trend, and it's becoming more and more in favor of low-income disabled tenants, permitting them some allowances because their income is directly related to their disability. For those of you in the private market world, another example, and I've had this a couple of times in my office, a resident wants to transfer or they want to terminate their lease early for a disability-related reason. The one I'm thinking of, the most recent one, was a resident wanted to leave her apartment, and I think she was on the 2nd floor, and move into an accessible unit in a different apartment community that had accessible units. Where she lived, they did not have them. She had muscular sclerosis, and her ability to walk had deteriorated significantly since she had lived in that unit. So now she was in a wheelchair, she really did need to leave the community and go to another one. And the manager explained all the early termination fees. And she said, I really can't afford those, so I'd like you to waive those. Well, the consideration there, I think, because this particular resident was very sympathetic in her position and in her situation, I think it would be a good idea in that situation to waive those fees, again, almost as a financial accommodation. There may be other cases where, no, it's not that important. The resident has lots of money, that you would follow your normal procedures. But let me just say, I would stop and look at those before you say, no, sorry, we always charge those fees. We're going to charge those fees to you. if the resident has asked you to waive them, you don't have to offer, but if they have asked you to waive them, I would certainly consider that as a reasonable accommodation.
Awesome, awesome, awesome. Very good. Any questions from the audience specific to Kathy's comments? This is the time you can put them in to the chat, or still a lot of you are using Slido for your questions. There's some other questions that came in from a couple other topics. Give me 1 second, Kathy.
I just saw one about, would you verify their need for the move? Yes, you would process that request for an accommodation the same as always. So if, well, in this case, in the one case I mentioned, now we have a woman who's a wheelchair user and your property doesn't have accessible units, I would not verify that. But if whatever the reason they say they need to move is not observable, then absolutely you can verify it.
Perfect, perfect. Okay, so that was a lot for 1 hour. Kathy, again, so many thank yous coming across on the chat for your expertise. Everybody like to, whether it's in the chat or in the question, you want to show your appreciation to Kathy, go ahead and give her a shout out for all that she's been able to provide for us today. Absolutely amazing, amazing material for all of us, and a lot to wrap our heads around. But our session isn't over. Even though this online session, we're going to conclude it. I'm going to take some of these questions over to Twitter and to our Facebook page. So if you want to go to our Facebook page, Kathy and I are going to try and get to some of these other questions we couldn't get to on our education session for today, and be able to interact with you a little bit more after the conclusion of today's call. Please take a moment if you are grateful for today's call. Again, this was complimentary. Kathy putting aside time for all of us to make sure that we're ready for 2020. So put a note out on our social channels. Connect with us on Instagram, Facebook, or Twitter, whatever you prefer. We do appreciate you as our community, because as you can see from today's call, we are here to help each other. This is a big topic. It's a very deep topic. And we have a lot of experts that are out there, a lot of experienced people within our industry that are there to help us and help each other. So what a great industry we have. You can't beat it being in the property management industry. Keep in mind, we do have online courses available for fair housing, for maintenance people, for your on-site staff, for senior living. Fair Housing in a Flash is our abbreviated course as a refresher. And coming soon, student housing. So we'll have a fair housing course for the student housing industry, and more to come in the near future. So keep an eye on your emails. Make sure you mark our emails to go into your important inbox so you don't miss any one of them. At the conclusion of this webinar, you're going to be redirected to a survey, and you'll be able to give us your feedback. And by filling out that survey, as another beautiful bonus to conclude today's session, you will be entered into a $100 gift card drawing for Amazon. So we appreciate your feedback. We're always looking to improve. Had a couple little technical mishaps today, but that's the way it rolls with technology. And all of you were absolute rock stars in keeping this going, and your feedback was amazing. So we want to thank you again. So hop over to Facebook and Twitter in just a moment, and we'll be able to take the rest of your questions. Kathy, again, thank you for your time. Everybody, have a wonderful, wonderful week.
Bye, and we'll talk to you next time.